Good morning. Happy Saturday. It's a gorgeous Saturday out here today. I hear it's flooding in Houston. That sucks. But next time you're making fun of me for living in California, it's gorgeous out here. Taxes! Yeah, it's beautiful. You pay more to live in a beautiful area. Anyway, everybody's all excited that I left out ample alternatives. Ample alternatives. Ample alternatives. That's part of the time, place, and manner test. And yeah, I normally leave it off for a reason, and that reason is when you're dealing with the police, when you're videotaping the police. I don't think that part really applies. I could be wrong on that. I probably was in error for leaving it off because I was talking in broader terms yesterday, although my intention was to discuss what the questioner had asked, which was about filming the police and having them push you back onto the sidewalk. So, mea culpa. Here's why I don't think it applies, though. You don't have a right to be at an accident scene or an arrest scene or anything like that. You don't have a right to be there. It is dicta, but it is accepted dicta, as in courts have been citing it from Brazenberg v. Hayes. So, with that understanding, they can exclude you, and they don't have to allow you an ample alternative way of actually seeing the crime scene. They just don't. I know, but they don't. So, another thing that is important in that it's not just ample alternatives, it's ample alternative channels for communication. And the fun thing about my voice crack there, I'm going through puberty. The fun thing about recording and photography is that it's not communication in itself, it's pre-communication. That's how it gets labeled as speech, because you never know when you're going to disseminate it. There's something in there that may not be useful or worthy of public dissemination. But at some future time, you might realize that you actually caught a picture of JFK's assassin or something. Who knows? So that's how recording or photography gets protected as speech. But the ample alternative channels for communication test was designed for actual speech, present, current speech. I'm a picketer, and I want to communicate my dissatisfaction with my employer, and if I can't hold a picket sign, then should I still be allowed to hand out pamphlets? Should I still be allowed to speak to passersby, et cetera, et cetera, et cetera? So that's what the ample alternative channels for communication was designed for. I don't think it really applies in cop watching or in filming cops arresting someone or something like that. Crime scene photography, things like that. So, your mileage may vary. I just don't think it's really pertinent to photography. They don't have to hand you a sketchbook. They don't have to give you an Etch-a-Sketch to allow you to record it in a different fashion. But I'm sure that some of the YouTube lawyers in my comment section will tell me how I'm wrong. But again, mea culpa, because I was actually addressing broader things, even though my intention was to put the specific thing in context. I was in fact talking about the broader aspects of the First Amendment. So that is an oversight on my part to not have included that. Another person asked me about the Miller test, significant or legitimate government interest in the Miller test, and I may have not been adequately clear with the Miller test and how that works. The Miller test is a test to see if the speech is protected by the First Amendment. It's not a test to see if the government can restrict the speech. It's a test to see if the speech itself is worthy of protection under the First Amendment. Not all speech is protected under the First Amendment, like, for example, child pornography or fighting words. Those are pretty common examples of it. But what the Miller test is doing is the Miller test is testing the speech itself to see if that speech can be protected by the First Amendment. If it can't, then the government doesn't have to face a First Amendment challenge. They don't have to justify the restriction on the speech because the speech isn't protected by the First Amendment. It's a little convoluted, and I get it, but they're testing the speech. So I hope that helps. There is no justification that the government has to do under First Amendment analysis to ban child pornography. It's just the First Amendment does not apply to it. The First Amendment doesn't apply to fighting words. If the government can show that the words you use were they would tend to incite a reasonable man to immediate violence, then it's not protected. It's just not protected. They no longer have to justify it under the First Amendment. They may have to justify it under other things, due process, whatever, but they don't have to justify it under the First Amendment. I hope that clears some things up. Anyway, I could talk about Minnesota Guardian. I don't really think I should. He got arrested for being stupid. Congratulations. On that note, I hope everybody enjoys the rest of their Saturday. Again, make sure you keep your mom in mind. Don't get arrested. Don't make your mom bail you out. Don't make her think about having to bail you out over the Mother's Day weekend, whatever, because that's pretty messed up for your mom. Have a great day.